Good evening. How's everybody? It's lovely to see you. It's really, really nice to see you. Can you hear me? Yes. Good. I want to make one correction, though. I've actually been here 2.5 years now, not just 1.5. It feels like maybe 1 year because it's been fun, it's been fast, and it's been furious. But it's really been 2.5, and it has been a lot of fun. My job this evening is to introduce our guest speaker, Alex Abdo, and it's really my true honor and privilege to do so. I first met Alex in 2005 when he was a summer intern at the National Legal Department in New York City, and I was a staff attorney in the National Legal Department. I think the first thing I sort of understood about Alex was that, he's a funny guy, very easygoing, very laid back, a jokester. Even just a few minutes ago, he was joking about how I ruined the pictures that everybody was in. Continues to do that. But beneath that, beneath his good humor and easygoing nature, is a really seriously committed civil libertarian. So even then, even as a law school intern, I knew that he had a really bright legal future ahead of him. So when he returned to the National ACLU to work first as a legal fellow and then as a permanent staff attorney in the National Security Program, I was thrilled. And my sense that he would become a legal star has, in fact, borne itself out. He will talk to you about some of the things, to talk to us about some of the things that he's been doing, most of it having to do with sort of challenging the draconian, wonder how that's going to be represented up there, the draconian tactics of the federal administration. Well done. And our post-9/11 landscape. So I don't want to talk much longer. I really want Alex to take the stage. But before I do think I would like to share with you that beyond being a fantastic lawyer, Alex is a sincerely good person. He's a good friend. He's loyal. Just a great colleague to have and a great friend to have. He's my technology consultant. He lets me know when the new iPhone model is coming out and that I should sign up to get it when it's released. And my former workout partner. So please help me welcome to the stage Alex Abdo.
Thank you so much, Reggie, for that incredibly generous introduction. And thank you all for coming. And it's really an honor to be here. So before I start, let me just apologize for having lost my voice a few days ago. So I'll do my best to be understandable. If I start to mumble more than normal, which is not out of the ordinary for me, but if it gets worse than usual, let me know, especially in the back if you can't hear me or understand what I'm saying. But I'll do my best. So I'm honored to be here, and I'm particularly honored to have been invited by Reggie, who you now know was a long-time litigator at the National Office of the ACLU, doing some truly groundbreaking work on racial profiling in this country. And slow down. So I mumble and I talk too quickly, which is not good for having lost your voice. So I don't want to date Reggie, but Reggie was a fantastic attorney and really a national litigator for 15 years at the ACLU, doing some really inspiring work, particularly inspiring to interns who were at the office and to junior attorneys. He was truly a mentor to people like me who are new to the organization. And so I think you are all incredibly lucky to have him here in Pennsylvania and in Philadelphia. Our loss is your gain, but it's really exciting to be here. Let me just also take 1 second to second Peter's recognition of John and Bonnie, who are with us tonight, and I guess Keith is not. But there's so much in this country that we would not know about but for the courageous acts of a handful of individuals, and we have two of them with us tonight, so thank you. So tonight I want to talk to you about the NSA. The last 10 months have been truly historic, and I want to put that into perspective for you just so you get a sense of how truly remarkable a shift we've gone through as a country over the last 10 months. So for the first 12 years after 9/11, the executive branch conducted sweeping surveillance in secret. Congress looked the other way, or worse, when it was forced to acknowledge the programs undertaken by the government, it endorsed them. And the courts either secretly approved of that surveillance, in the case of the Foreign Intelligence Surveillance Court, or in the case of other courts, it refused to enter the debate. One of our last encounters in court with the NSA prior to the Snowden disclosures occurred in February of last year, when we were suing over one of the most sweeping surveillance laws that Congress has ever passed, a law that was enacted in 2008. And by a 5-4 vote in the Supreme Court, the court said that we were not entitled to sue. It washed its hands of this surveillance law, a law that was having clear consequences for human rights activists, for lawyers representing Guantanamo detainees and others, for journalists who work in either areas of foreign policy interest of the United States or who talk to those who might very well be of intelligence interest to the FBI and the NSA. Despite those consequences, the Supreme Court said, you're not allowed to sue, essentially sealing the fate of that lawsuit and other lawsuits like it. That all changed on June 5th, 2013, which was the day that The Guardian published the first of the Snowden articles. Since then, in the last 10 months, a short 10 months, there have been literally dozens of reform bills proposed in Congress. One of them nearly passed by a vote of 217 to 207 in the House, which, if you've been following surveillance litigation since 9/11, is a number that would shock you. Normally in the House, we expect to see 20 or 30 stalwart defenders of civil rights standing up for our rights, and maybe a dozen in the Senate. So the fact that we nearly enacted reform legislation just weeks after the Snowden disclosures was truly remarkable. The president himself, for his part, has decided to end at least one of the programs, and he's instituted a number of other important reforms, some of which were recommended to him by his own hand-picked review group, although he has still to date fallen disappointingly short, but still, in less than a year since the disclosures, one of the NSA's signal programs is on life support with the president endorsing its end. And the courts, for their part, prior to the disclosures, never seriously questioned the NSA's activities, but since the disclosures, the courts have split 50-50 on whether one of the NSA's programs is unlawful. One of the courts, the one on the right side of history, called the program almost Orwellian. So that's where we've come in the last 10 months, what a difference an informed public makes, what a difference it makes to have the public involved in these weighty questions in a democracy. But the work is far from over. And tonight I want to talk to you a bit about how the ACLU thinks about NSA surveillance and privacy more broadly. And I want to give you a sense of what we're up against, what the fight about privacy might look like in the future, and what the ACLU is doing about it. So to get there, I want to start with a little bit of NSA history, because I think it's important to understand where we came from if you want to understand both where we're going and how we have a chance of combating it. So the NSA was founded in 1952. There were predecessor organizations dating back to World War I, but it really started in full force in 1952, and really from the outset it was operating without any regulation by Congress. It was essentially a lawless organization, and that, it turns out, largely dictated the types of surveillance programs it engaged in. And that all changed really in the 1970s, beginning in the early 70s with disclosures like the COINTELPRO program, leading up to a 1974 article by Seymour Hersh in the New York Times revealing the CIA's crown jewels, the family jewels of the organization, information about the worst excesses of the intelligence agencies. And those revelations of large-scale domestic spying fueled reform in this country. They led immediately to the creation of the Church Committee in the Senate and the Pike Committee in the House, headed by Frank Church and Otis Pike. And those committees uncovered vast illegal spying by the intelligence agencies. And the essence of the problem was that the agencies were using their authority to acquire foreign intelligence as a pretext for large-scale domestic spying. They said they were outward-looking, but in fact they were looking at every one of us. That's what was happening in the 70s, and it's reminiscent of the debate of late. The result of those committees and the result of the reform efforts after were that Congress, for the first time, passed law regulating the NSA. Congress, for the first time, formed bodies that would oversee the NSA. The Foreign Intelligence Surveillance Act, or FISA, was enacted. It was a law that limited the NSA. It did away with much of its bulk collection of information and required it to be targeted in the way it went after surveillance targets. The Church Committee eventually became the Senate Intelligence Committee. The Pike Committee eventually became the House Intelligence Committee. And those two committees since have been overseeing the ways in which the NSA and other agencies undertake surveillance in the name of national security. And so what I want to leave you with that kind of history lesson is that we made a trade in the 70s. We learned of vast spying by the agencies, and we made a trade. We said we would accept a lot of the surveillance that was going on when it was necessary, but we would subject it to oversight. And though that oversight was largely secret, it was understood that it would have bite. And that state of affairs persisted for about 25 years, from 1978 until 2001. But after 9/11, the NSA's mission dramatically shifted. And I think there are really two key things that we've learned about the NSA from Edward Snowden. And, I think it's difficult to keep track of the disclosures and the nature of the programs that the NSA is engaged in. And I don't want to go through a catalog of the types of programs. I'll explain a few of them to you in some detail, but I want to leave you with the way that I try to grapple with the extent of the disclosures, because they can be bewildering at times. The technology is confusing. The legal landscape is even more confusing. So here are what I think are really the two takeaways from the disclosures that started on June 5th of last year. The first is that there's been a shift away from targeted surveillance toward bulk surveillance. And it's difficult to overstate how important that shift is. The NSA, for the first 25 years of its legal regulation, from 1978 onward, based most of its surveillance on individualized suspicion of wrongdoing or individualized suspicion that someone was a member of a foreign government or a foreign power. That was the model of surveillance. And in part, that was largely driven by technology. It was just not possible for the NSA for the latter half of the last century to do much more than that, at least inside the country. But that shift happened after 9/11. And the shift is apparent in a number of different ways. There are a number of programs that have manifested this kind of bulk collection. There's the phone records program that we've all heard so much about, the very first one disclosed. This is the program under which the NSA, every single day, collects a record of every phone call made in the country. If you've picked up a phone today, by tomorrow morning, a record of that call will be in NSA hands. They'll have a record of when you made the call, who you were talking to, and how long the call lasted, and perhaps even some information about where you were when you made the call. For many years, up until 2011, the NSA operated a very similar program on our internet usage. They would collect the so-called metadata of our emails, who you were emailing, when you were emailing them, how often you were emailing them. But it went beyond emails. They collected information about the websites you visited, how often you looked at them, how long you stayed on them. All of that information was being collected on a daily basis about ordinary people inside the country with no suspicion of wrongdoing. That particular program ended in 2011, not because it was found illegal, although it is, but because of so-called operational concerns, which is to say that the technology became difficult for the NSA, but you can bet your hat that as soon as they figure out the technology, that program will be up and running again unless we succeed in putting legislation in place to prevent it. There were other programs. The CIA had a bulk financial records program that is still, so far as we know, operating. There were programs being operated that would detect the location of people around the world, including Americans, as they traveled. We don't know much about whether and how that program is operating today, but there are reasons to believe that there is some form of mass location tracking program in operation, if not in the U.S., then certainly outside the United States. That's the bulk collection that we've learned about. There's a related form of dragnet surveillance that is in some ways even more problematic. I'll describe it briefly now, and I'll talk about it more in a bit, because I think it really will be the model for the future of surveillance by the NSA unless we can stop it. And it's more pernicious, I think, because it is not just about so-called metadata. It's not just about the information about who you're communicating with and when. It is the actual content of your communications that the NSA is scouring through daily, particularly when you're calling someone or emailing someone outside the country. It turns out that if you engage in any kind of text communication with someone abroad, the NSA is scanning the contents of that text for selectors, which are, as best we can tell from the public evidence, suspicious keywords that might relate you to one of their targets. And if you're a hit, if one of your emails or text messages has one of those selectors, then it's shunted off into another database and preserved perhaps for years. There's another program called the Mystic program that recorded the phone calls of a single country for a 1-month period on an ongoing rolling basis so that the NSA can peer back in time for the last 30 days in case they discover a new intelligence target. That program, I think, is the logical endpoint of some of the arguments they're making about their authority, and it is, in fact, currently in operation, and there may be 5 or 6 other countries on the list already, according to recent reports. So that's observation 1 about what we've learned since Edward Snowden enlightened us. There's been a dramatic shift toward bulk collection, away from targeted surveillance toward bulk collection and dragnet surveillance. The second one is a structural observation. It's insight we gain from Edward Snowden about the ways in which these programs are overseen. And I don't think I need to tell this audience that a little bit of distrust in government is healthy in a democracy. It keeps the governors accountable to the governed. It turns out that the oversight structures that were put in place in the 1970s have, at least in the last decade, fallen into a state of complacency in this country, where there wasn't meaningful oversight, where those tasked with overseeing agencies behind closed doors weren't sufficiently accountable to the public, and as a result, didn't do their jobs. So I told you, a few minutes ago that we had this compromise in the 70s where we agreed to oversight that would be largely secret, but that oversight has quite clearly failed, and you can see it pretty clearly if you look at each of the branches. So to start with Congress, Congress either, if you listen to some of the statements of senators and representatives, they either didn't know about some of these programs, which would in itself be a scandal, given that it is Congress's job to oversee these programs, or they did know about these programs and did nothing to stop them. That is one of the failures of secret oversight. No accountability. The courts, and primarily the Foreign Intelligence Surveillance Court, which was the court created in the 1970s to oversee these programs, approved these programs in secret based on secret legal interpretations of the law that were not subject to adversarial ruling. There was only the government appearing behind closed doors to contest the NSA's sweeping interpretations of laws. And so quite predictably, the court endorsed those interpretations, approved of the rationales offered by the government. But we've learned since the Snowden disclosures that even setting aside the questionable legal rulings of the court itself has acknowledged its own limitations. It has said that it doesn't have the capacity to meaningfully question the representations made to it by the NSA. That's in part because the technology is difficult. It's not easy to understand, and the court doesn't have someone on hand to explain it to them. And it's also because the court is operating solely based on the government's arguments. And it turns out it's very difficult to arrive at the correct solution when you don't have two parties presenting both sides compellingly to you. So that is the state of affairs as of the beginning of the Snowden disclosures. You have an executive that has run amok with its authorities, in part based on secret authorizations. You have oversight mechanisms that have failed and that have resulted in broad legal questions that impact the privacy rights of millions of Americans at a time, being decided entirely in secret without any accountability. Entire programs of surveillance approved without any democratic oversight or democratic buy-in. So that's where we are. And I think that should be enough to scare you, I hope. But it gets scarier. And I think it gets scarier because one of the things that we've learned, a principle in the law we have these kind of shorthands for how you're supposed to interpret statutes. We call them canons of interpretation. And they're supposed to help us understand vague laws because Congress cannot always be bothered to clarify what its laws mean, and so courts are forced to interpret those laws. And I think there's an important corollary when it comes to interpreting NSA authority, which is this. Always assume the NSA is doing it if it has the capacity to do so, and there's even a plausible legal argument that would allow it to do so. That, I think, is what we've learned in part as a principle from the Snowden disclosures. And so taking that principle, I want to share with you a few observations about how the NSA has defended these programs, the legal arguments it has advanced. Because if you understand those arguments, you get a sense of what they have in mind for us for the future. So one of the very first arguments that the NSA made after the disclosure of the phone records program, this is the program under which they collect a record of every call every day. One of the first arguments it made is that, don't worry, it's just metadata. Records about who you're calling and when you're calling them is just metadata. It's not the contents of your calls, and so it's not sensitive. It's not protected by the Constitution. It's not protected by the Fourth Amendment. You have nothing to worry about. The problem is that virtually everything we do today leaves a digital trail of some sort. It leaves metadata behind. When you send an email, when you visit a website, when you make a call, when you use your credit card, you leave digital trails in very obvious ways. But even when you're not intending to leave those trails, when you're not intentionally engaging with technology, your technology is tracking you. Most of you in the audience have very sophisticated surveillance devices in your pockets right now. And those devices are only getting smarter. They're only getting nosier. There are versions of them today that track the way that you walk, that can predict your gait. And there are people working very hard to figure out how to use that sort of biometric as a way of identifying people in large crowds. So it turns out that everything we do is metadata in one way or another. And so under the NSA's interpretation, all of it is fair game. And it's not just fair game subject to the sorts of restrictions that the NSA assures us are in place for the phone records program. They're fair game in the sense that the Constitution doesn't even apply, according to the NSA. So it's great that we have some restrictions on these programs now, but if the NSA prevails in court on its arguments, those restrictions will be just a matter of executive grace and not legal restriction. So that's one of the arguments the NSA is making and what it might mean for the future of surveillance. It might mean that virtually every time you engage with the internet or technology, you leave a digital breadcrumb for the NSA to pick up. The second argument that they make, which I think is perhaps even more troubling, is that the collection of our information in and of itself doesn't invade privacy. That the invasion of privacy only happens later on when the NSA searches through its databases. That is one of the arguments that it makes in defense of the phone records program. There's nothing to see here. There's no constitutional violation. The Constitution isn't even implicated until we later search. And of course, they'll never tell us when they later search, so by the way, there's no standing to challenge these programs. But that argument has even more astonishing consequences for privacy, because it would mean that the NSA could collect not just our metadata, not just information about who we're calling and when, but could collect the contents itself. And I worry about it, and I want to tell you just a bit about what we at the ACLU are doing to fight it. And then I want to open it up to questions, in part because my voice is failing me. So I think the first lawsuit we filed after the Snowden disclosures were on June 5th of last year, which was a Wednesday night, which I'll never forget. And the first lawsuit we filed was on a Monday. The second lawsuit we filed was that next Tuesday. So within 5 days, we had filed 2 lawsuits. And I want to tell you a bit about those efforts. The kind of flagship lawsuit right now is a case called ACLU versus Clapper. The defendant is James Clapper, who's the Director of National Intelligence. He's the one who I'm sure you've seen on TV, who was asked by Senator Wyden some years ago, does the NSA collect information on millions or hundreds of millions of Americans? And he looked up at Senator Wyden and said, no, not wittingly. And he later described that answer as the least untruthful response he could have given. So he's the defendant in one of our lawsuits. And that lawsuit is the one challenging the phone records program. It's a constitutional challenge under the Fourth Amendment and the First Amendment. We unfortunately lost our challenge in the trial court. The trial court found that it was bound by a 1970s Supreme Court decision. But in a related case filed in D.C., another court found quite the opposite and said this program was almost Orwellian and struck it down. Both of those cases are now on appeal. Our next brief is actually due on Thursday. So I should actually be back in New York working on that brief, but we have a brief due Thursday, continuing our challenge to the phone records program. We have another suit brought in a criminal case challenging the FISA Amendments Act, which was the 2008 law that Congress passed ratifying warrantless, suspicionless surveillance. We have a number of Freedom of Information Act requests seeking to uncover the full extent of NSA surveillance. We know a lot about the bulk collection that is ongoing, but there is even more that we don't know about that is ongoing. Other bulk collection programs, other dragnet surveillance programs, we're litigating those cases actively. We have 2 cases in front of the Foreign Intelligence Surveillance Court asking the court to declassify some of its opinions, the opinions that interpret the Constitution and interpret our federal laws in broad and sweeping ways, the sorts of opinions that in most democracies are available for the public to read but have not been in ours for the last few decades. We're pushing for legislative reform in Congress but also in a number of states. Our main focus when it comes to the NSA has been to push for reforms to these programs, to end bulk collection, to end warrantless surveillance, to end excessive secrecy, to require the government to own up to these programs, to bring the public into the debate. And we've also pushed for structural reform of the oversight bodies. We've pushed for reform of the Foreign Intelligence Surveillance Court, for greater resources devoted towards some of the other bodies that help oversee these programs. And lastly, we're starting to think very seriously about the role that private companies have to play when it comes to privacy. Because even if we limit the NSA in some of its more sweeping forms of surveillance, private companies have a very unique role to play when it comes to our privacy. They can enable privacy by engineering their software in such a way as to endorse privacy, make privacy easier, make it more difficult for the government to engage in broad surveillance. And they can embrace policies that are more consistent with privacy, policies that don't result in the large-scale, indefinite collection of our data. So that's what we're doing. That's the fight. That's where we're going. And I am an optimist. I'm bullish. I think that we will end some of these programs. I think the fight on some of the other programs will continue for a long time, especially as technology makes pervasive surveillance easier for the NSA to engage in. But whatever the results, there's no question that we are now in the midst of a truly historic conversation about privacy for the first time in really 4 decades in this country. And so we may not win every battle, but we're at least now, for the first time since 9/11, fighting the merits of these battles. And that in and of itself is refreshing. And that, I think, every day makes this fight worthwhile. And so, thank you for all of your generous support in doing this work.